Hello, beautiful people. Welcome back. At law and equity. There's several components to law. Equity being an extension of at law. Equity being a world of its own. Equity is not an isolated mode of operation from at law. Many would like to demonstrate as though it's something different from at law. It is merely an extension, and in some case, perfection of at law. Equity is still a set of law of its own. In most cases, you will find a lot of at law doctrines, principles, heritage, and history directly involved with what most people refer to as equity. And when you begin to look into equity, you will see a lot of things regarding England, regarding the Scots, regarding the Druids, and things like that. But more often than likely, you will see things relating to the English. So on one hand, many people are saying that they are trying to get away from this system. But in modern time, the system was created by the English people who left a part of the world called Great Britain, which is a conglomerate of England and Scotland, who came to one body politic called United Kingdom. And some of the serfs there came into the Americas after their brothers and sisters, Portuguese, the Spaniards, French, the Dutch, the Germans. See, all these different names and all these different families and houses that were just mentioned, they're all cousins. All of them. The Kaisers of Germany, the Tsars of Russia, and the kings of England, and the kings in that part of the world called Asia Minor, and the kings in the Americas, the islands, north and south, all that. All of them are cousins and are related. So if you are one part of the world in North America, what does that mean? That means that the interest in estates are apportioned to those who it rightfully belongs to. But nonetheless, there's always a bloodline link, one way or the other. And by virtue of that, once brother fights against brothers, when sisters fight against sisters, they usurp their own interests. Whatever vice is involved, the human impulse, the need, or interest, one brother usurps another. Whatever spite might exist once upon a time in the past that is still currently going on, none of those are isolated incidents. So if you are at North America, you're saying on one hand, these other guys are the bad guys. They created the United Nations, the Pope, all of this, Church of England. Okay. And then you're saying common law is the only thing that will help us. Common law is what it is. Common law is judge-made law. Common law is what the real man uses. Or you also say equity. Equity is where it's at. Equity is the jurisdiction. Maximus of equity. But you really don't get the fact that what you call common law, regardless of whether it's a state common law or the judicial interpretation of the legislative department of government, aka judge-made law, whatever it is you say common law is, or whatever now you're running to because you fail to really comprehend the principles, the doctrines, and the operation of law. And now you're just looking for the next trend and the next bandwagon to jump to, and you say, oh, equity, yes, it sounds good, it sounds cute, even though you really don't know what it is. Yes, you've read a couple of maxims of equity here and there. Now what? you don't understand or comprehend that these same people that you say you're getting away from are really, their laws are homogenized with that thing that you're saying you're using, common law. That's right. English law is homogenized with common law. English law is homogenized with equity. We're not saying common law and equity are the same thing here. We're not saying common law and equity are bad, but we're saying be realistic. Know what it is that you are getting yourself into. Look into equity. Research it. I will be doing you an injustice to show it to you here. Go, just look into it. Look into equity. Look into where it's from. Look into common law. Look into where it's from. If you are at North America, some of your progenitors came through the Transportation Act of 1777, and you are also saying that the Constitution and the preceding documents and other constitutions, which are treaties, is something that you ought to not use because it's theirs. Even worse, if you're saying you're primogeniture, or you're saying you're North American, or you're saying you're an American, or you're saying you're more or one thing or the other, and you're running away from the Constitution, good. You keep doing that. You keep doing that. Hopefully one day nature does not put you in a circumstance that's going to make you learn the hard way. If you keep looking at things from an isolated perspective, if you think these things that are being studied, equity, common law, commerce, the different types of law, the different types of rights, the different types of doctrines, etc., etc. And we're only even, in the past, we've only even spoken about things at law, not the doctrines that exist at equity. If you do not comprehend at law and the simplicity of its origin and how it relates to what you think you're running away from as the bad guys, you are getting nowhere. You don't want to study all these things just to only interpret it from the point that makes you feel comfortable. You have to be realistic and see things from its true totality of circumstance, not from an isolated perspective of your personal interpretation or what you heard somebody else told you. Nothing is isolated, especially if you're claiming origin to a certain landmass and you don't even comprehend the modern stuff, because when you really look at it, equity that everyone is running into is actually modern. That stuff, it incorporates some ancient principles, but equity is not as modern as people think it is. So you're saying you're primogeniture to a land, or you have some right of claim, right? You're saying something about your bloodline, or you're saying you're a man in the land or a free man if you're not claiming primogeniture status. And your limits is just equity, you're not looking far back enough. You know that thing called Black's Law Dictionary that everyone loves so much? It tells you something very unique right on its face. First page, if you have a physical copy or an electronic copy, go to the first page regardless of what edition. First edition, second edition, fourth edition, whatever it is, the 9th edition, go to the first page. Read what it says. It says Dictionary of Law. Definitions of the terms and phrases, listen to this, of American and English jurisprudence. Of American and English jurisprudence, comma, ancient and modern. Do you know what this just told you? The same dictionary that everybody runs to, that everyone cites. When you read some papers and there'll be 3 pages of citing Black's Law dictionaries, and you're going, wow, you could have really opened and closed the whole case within all these 3 pages of citing all these dictionaries. terms that serves you no purpose. But this thing that everyone loves, this Black's Law Dictionary, whether it's first edition, second edition, third, all the way, it would always at the beginning, first page, to tell you it's a definition of terms and phrases of American and English jurisprudence, comma, ancient and modern. Do you know what they're telling you here? They're telling you that it's referring to American jurisprudence and English jurisprudence. And the similitude, it's ancient and modern. Within the format of English language, especially in legalese, when things are formatted like this, the fact that they use this term ancient and modern, they are using it as a reference to qualify two specific things, two respective words that came before them. This ancient is referring to American, modern is referring to English jurisprudence. We'll say that and leave it there. Now you studied equity because, you know, it's now the fashion and trend that everyone is jumping on. And equity is an English mode of operation. But then again, these English people are the ones that were ran away from, you know, taxation without representation, founding fathers, right? It's their court, it's their jurisdiction, it's their laws. Yet you're using English law. We're not saying one thing is bad or good here. What we're saying is know what you're doing, know what you're getting into. And know that these mere terminologies, common law, equity, English law, American law, they have their own place. They are perfect placeholders for certain things. There's a video in the past that referred to dishonor and commerce, and the details of that was briefly went over. It's telling you two different types of jurisprudence is encompassed in this law dictionary: American jurisprudence and English jurisprudence. Think of it as like how Mexicans speak Spanish. People who refer to themselves as Mexicans, they are speaking Spanish. Spaniards speak Spanish. So now you hear an American using an English law, English jurisprudence. Is there something wrong with that? No, there's nothing wrong with that. Because the monarchs, the English monarchs, Scottish monarchs, and the monarchs here in the Americas, the American monarchs, they're all families. And when you intermarry as a form of treaty or alliance, your laws are intertwined, inevitably. So it all comes down to who are you really? And who you are really is what allows you to invoke certain laws, certain types of jurisprudence. Sit down and be truthful to yourself. So much so that, for instance, Florida, an old Spanish jurisdiction, within their state common law, first title at the beginning, just like Black's Law lets you know on its first page, Florida, the website, the official publication for the Senate, the Legislative Department of Florida, lets you know in its first title, construction of statute. Of course, we know construction deals with type of trust. So bear all that in mind as we speak. It tells you about the definition of Chapter 1. Chapter 2 tells you about common law in force and about repealed statutes. Section 2.01 regarding common law. It tells you common law and certain statutes. Now, this is not the only state this is in. This is just the state that I notice most people are commonly referring to. And most people that I've spoken with are from here. So this is the quickest example that I can give. But it's in many other states. Common law and certain statutes declared in force, meaning it's fully enforceable in a public notice of it exists, then it's undisputable. The common and statute law, two different types of laws. The common and statute law of England. Now, this is Florida here that we're speaking of, which are of a general law and not a local nature, with the exception hereinafter mentioned, down to the 4th day of July 1776, are declared to be of force in this state. The common and statute law of England, which are of general nature, with the exception hereinafter mentioned, down to 4th of July 1776, are declared to be a force in this state, so long as it's consistent with the Constitution of the state, the laws of the United States. You see how common law of England is now homogenized with the Constitution on the state level, the Republic, and the United States level, which is the one we went over, which is a democratic form. After the adoption of the Confederacy, which is the Republican form of government, which is the Article of Confederation, which is the United States for America, quote unquote. Yeah, you will never find a document that says that verbiage. We went over that in a previous video regarding the Constitution for and the Constitution of the United States. But after the adoption and readoption, after the adoption of the Articles of Association, Confederation, and other treaties through congressional records, is that Confederation and the Constitutional Convention, believe it or not, was the Iroquois Confederacy. That's another subject. But nonetheless, after the adoption of the Association Declaration, which really has its root in the naturalization laws for certain people, which led up to the democratic version, which is the one that was ratified in 1791, known as the Constitution of the United States. All that has been homogenized along with the independent Republican states constitution with English common law statute. So the question you ought to ask yourself is, what are you purporting to do when you're going into equity? Presuming you know everything you need to know about at law first. Because if you don't know about at law, you are not going to survive at equity. And when you begin to look into equity, is that really the end game? Is it really the end game? Are there other bodies and mode of operation, other bodies of law that can be used outside of at law and equity? Who are you purporting to be to have a right of claim to enforce these things? These are the reasons why they do psychological evaluation of people. Believe it or not. These are the reason why. So be honest with yourself about what you are doing. Just a very small food for thought, but very crucial in your ability to actually enforce the law. Otherwise, hey, there's a lot of statutes out there for you. Best of luck. Hey, and also don't forget to join my Patreon if you haven't. There I go through documents that I have used personally successfully and videos that I do not post here on YouTube that are in many ways private in nature. And also I go through live audio interactions and video interaction of my own experience with certain things. And I also have a website where you can go through a list of documents or services if you need them. And These videos that are posted on YouTube are also uploaded on Anchor. You can listen to it via audio means. And there's an Instagram page and a Facebook page. The link is on the screen and in the description. Take care and best of luck.